Good morning and good afternoon to everybody joining us. As we are at 12:01 and have a packed agenda, I'm going to get us started. My name is Kelly Mulligan. I am a Senior Director for Court Reform for the Center for Justice Innovation. Welcome to part 4 in our webinar series on municipal courts. This webinar is going to highlight best practices for court practitioners, and we are honored to have 3 judges on our panel today whose work across the country really exemplifies a lot of the best practices that we are going to be discussing. First, we have Judge Timothy Kuhlman. Judge Kuhlman joined the Toledo Municipal Court in 2005 and served as presiding and administrative judge from 2007 through 2010, again starting in 2019 through 2020. As presiding judge, he worked closely with other judges, the Toledo Bar Association, city and other government officials, and interest groups and advocacy groups to continue improvements in the Toledo Municipal Court to ensure efficiency of operations, both budget-saving measures, and justice for all people who are served by the court. We also have with us Judge Mary Logan. Judge Logan has been practicing law for over 37 years, both in California and in Washington State, with a broad range of experience, first as a plaintiff's medical malpractice attorney. That is a mouthful, Judge Logan. From 1988 to 1994, and then civil defense work representing 13 cities along with the Central Coast of California. She moved to Spokane, Washington in 1996 and was brought on by the city of Spokane's Public Defender's Office in 97. She was then appointed to the newly minted municipal court bench in 2009, where she remains seated. She was presiding judge from 2009 through 2014, as well as from 2021 to 2023. And finally, we have with us Judge Linda Cooke. Judge Cooke was the presiding judge at the Boulder Municipal Court for 22 years, retiring in June of 2023, now serving as an associate judge. Hallmarks of Judge Cooke's work at the court included extensive use of restorative justice, procedural fairness, and alternative sanctions that seek to address the problems underlying law violations. She has a long and deep history of partnering with the University of Colorado at Boulder to develop a coordinated response to high-risk alcohol use by young adults and offenders and the impacts on the community. As just some examples of her work. So to get us started, I'm going to turn us over to Judge Kuhlman. And Judge Kuhlman, take it away.
Thank you, Kelly. Good afternoon now. I'm going to start by letting you know that polling shows public trust and confidence in government is low and falling. The judicial branch had historically been rated better, but recently we have fallen also. Municipal court judges should know that 80% of all criminal cases across the country are in fact low-level misdemeanors, our cases, and misdemeanors, again, our cases make up 25% of jail populations in the country. So we are significant to public perception. Procedural fairness, sometimes also called procedural justice, is a method of communication that improves not only trust and confidence in the judiciary, but also increases compliance. If we use procedural fairness, the people before us are more likely to follow our orders, the system spends less time and money enforcing our orders, and we and the people in front of us are better off. Procedural fairness is simple and it's free. As much money as we spend trying to enforce our orders, why would we not engage in a communication method that costs nothing and increases compliance? Studies prove the use of procedural fairness principles of voice, neutrality, trust, and respect is effective in changing behavior and reducing criminal justice contacts. This change comes from the limited amount of time that it takes a police officer to issue a citation or the limited amount of time it takes a judge to issue a ruling from the bench. By ensuring individuals feel respected, feel heard, and feel treated neutrally, we've discovered a powerful tool for long-term behavioral change. The results are staggering. Participants are more likely to comply with law enforcement and judges, engage constructively with legal processes, and make different choices. Following these principles leads to trust in the system and compliance with the system. So defendants will show up in court without bench warrants, no contact orders are followed, and probation are successfully complete without violation. People treated with procedural fairness tend to follow the law in the long term, and they also tend to cooperate with the system as witnesses or jurors when they are called. Procedural fairness is a new method of communication that I like to contrast with an older method, which we call command and control. We used to say, I order you to do something because I have more knowledge, I have more authority, and I have the power through my position, for example, as a police officer or my position as a judge, to force you to do it, and therefore you must comply. We find that method of communication is not as successful, and procedural fairness is better at obtaining voluntary compliance and more consistent and long-term compliance. A significant complaint about procedural fairness from a lot of judges that I've helped train is that it takes too much time to do the training and it adds too much time to the docket, particularly allowing for voice, an opportunity for people to be heard. As to the training time, I like to tell a story attributed to Abraham Lincoln. He said, if you give me 6 hours to chop down a tree, I will spend 4 sharpening my axe. Training is important. We can save ourselves a lot of time by being properly trained, and once people are trained in procedural fairness, it's free. As far as adding time to the docket, think about this. Why is there always time to do it right the second time around? If procedural fairness results in fewer bench warrants, fewer protection order violations, fewer probation violations, and greater long-term compliance with the law, it is more than worth the extra time. So why don't we take the time to do it the first time, and then we don't have to spend the time the second time around? I also point out that as long as you require people to stay on point and be specific to the immediate topic at hand and do not allow people to repeat themselves, allowing voice really does not add that much time to the docket. 10 years ago in Toledo Municipal Court, we created a procedural fairness training program that included everyone who works in our building, from the judges to the cleaning crew. The judges, by the way, I think you'll all agree with this, were the hardest to get to the training. And the judges who don't need procedural fairness training are the first to sign up, and the ones who really need it refuse to go. The only sales job I found that works with those judges is to ask them to do it for employee morale and to be with their staff. It is important to understand, if you want your staff and all the people in your courthouse to treat people with procedural fairness, it is important to you, and you had better start by treating your staff with procedural fairness. So you must have buy-in on procedural fairness from your fellow judges, the magistrates, your court administrator, and your managers. Our training program included our entire judges division, probation officers, secretaries, even IT and finance, people who don't generally have participation with the public. We included our public defenders and private attorneys. We included our prosecutor's office staff. We have a separately elected clerk, and she and her senior staff bought in completely and attended the first training. We included the sheriff's office, which provides security and prisoner transport in our building, and we also included the Toledo police officers who are assigned in our courthouse as liaisons with the prosecutors. This joint training did 2 very important things in our courthouse. First, as we announced at the beginning of our training, the point is to create a common goal and a common language to talk about and achieve the goal of procedural fairness. That stated goal was met. Second, which we didn't necessarily intend, but was a byproduct of the training, is we broke down the silos in the Toledo Municipal Court. We got to know and understand each other better, and we got to know and understand each other's jobs better. So this is what our training looked like. We had an 8 to 10 person training program that had representatives from all of these groups that I mentioned. So it wasn't just the judges division. We had sheriff's deputies, and we had people from the public defender's office and other parts of the courthouse. And they also included line staff to managers. Although my court administrator and I coordinated the training, we only did introduction and wrap up, and we allowed others to lead different sections of the training. Each training was 1 6.5-hour session, so people were done in one day. Each training had 20 to 30 participants, which we broke up into 4 to 6 groups of 5 people for smaller group discussions. In those small group discussions, we were careful not to allow public defenders or sheriff's deputies to all be in the same group. We have over 200 people in our courthouse, so to accomplish this training, it took several years, doing it every few months. New hires were added to the training as part of the next training as part of their orientation. And after everybody was trained, and we completed this about 6 years ago, I would say, we did a couple of more trainings for the new people, so everybody in our courthouse is trained. We are now in the process of creating a 2-hour refresher course so that we can continue our work toward procedural fairness. This training was so popular, we even put on 2 for our community-based corrections facility in town. So think about what procedural fairness looks like in a court. A defendant gets up in the morning at 6 o'clock, sees deputies who bring him over the court, talks to an attorney he doesn't know, sees a judge, sees a probation. If each of those interactions treats him like an animal in a cage or a criminal, by the time he gets to the judge, his attitude will be so bad he can't help but get a bad decision and a bad result. However, if each of those is done with procedural fairness, his attitude is going to be very different and he will get a better result. We owe it to him, to us, and to our communities to make sure that we do what we can to make sure that the defendants in front of us get the best results, which means they improve their lives. By replacing command and control with procedural fairness, we will have more voluntary, consistent, and long-term compliance. Judge Cooke is going to talk a little bit about implicit bias, and practicing procedural fairness can also be an antidote to that. We believe procedural fairness is so powerful that with the help of the Center for Justice Innovation, we created a 3.5-hour diversion curriculum for persistent offenders based on procedural fairness. Over 8 years, we've had 3,000 people attend the program with a 64% successful completion rate. We have done surveys over these 8 years with all 3,000 people. 94% of the participants in this diversion program said they learned at least one new coping skill. Think about that. 94% said they learned a coping skill from our diversion program. 81% said they gained a new perspective on criminal justice. Their perspective on criminal justice is cops are unfair. They now have a new perspective. 97% even said they would recommend the class to others. What all that means is their next interaction with the police from this group of persistent offenders is going to be different and less likely to result in their arrest. We believe this program is improving individual outcomes and increasing public safety and trust. The Access to Justice Lab at Harvard Law School has started a rigorous randomized control study of our curriculum, and in a few years, at the conclusion of the study, we hope to add our diversion program to the list of best practices under procedural fairness. We are working on adding procedural fairness training curriculum to our Toledo Municipal Court website, and we'll add updates to our Harvard study. So in the future, take a look at toledomunicipalcourt.org to get updated on that. We're now going to see a video clip of Judge Amy Bachman from Broomfield, Colorado Municipal Court demonstrating the use of procedural fairness.
Qualify for a free attorney? Based on this case, would like to enter a not guilty plea and exercise your right to have a trial, where the city attorney would have to prove the charges beyond a reasonable doubt. Is that your understanding? Okay. And you have a choice with that trial between a court trial and a jury trial, and you're requesting a court trial. Is that correct?
Correct.
Okay. Any questions about that?
No.
Okay. All right. So not guilty plea will enter. The matter will be set for a court trial. Now, Mr. McDermott, are you going to be hiring an attorney or applying to see if you qualify for a free attorney?
No.
You don't want to exercise your absolute right to have an attorney assist you?
That's correct.
Okay. And do you have any legal training?
No.
Okay, and these are some questions that I ask of every individual that wants to represent themselves at trial, so it's not specific to you. But the law requires me to kind of inquire about whether or not someone has the education or the skills to represent themselves. And the reason that I ask is because this is a serious charge. It's shoplifting, and the possible penalty for that charge, if you were to be found guilty, is a jail sentence of up to 364 days in the county jail and a fine of up to $2,650. So, with that, I just want to see what training okay, and I appreciate that. What's the last grade in school you've completed?
1 year in college,
Okay, all right, what did you study?
environmental law.
Oh, wow, okay, all right. And so you have, it sounds like some expanded or extensive education, but you understand this isn't environmental law, right?
I do.
Okay, this is criminal law. And so do you have any training in that?
No, but I understand that I
Fair enough, fair enough. And you wouldn't,
there.
okay, and I don't want you to make any statements, and it's hard because I know I'm having this conversation with you and asking you questions, and then I'm stopping you when you're speaking, but I don't want you to make any statements that could wind up being used against you at your trial. You're gonna have the opportunity if you so choose. Okay, all right. So with that, then, you're indicating you understand how law works, and I appreciate that because you understand the law can be very confusing, right?
Yeah. And
And if you don't have any actual legal training, it can be very difficult at trial to represent yourself. You understand that?
Yeah.
And if you made the decision to apply to see whether or not you qualify for a free attorney, the court could then take a look at that application that you filled out and make a determination as to whether or not the court could just appoint an attorney to represent free of charge. You understand that?
Yeah.
Do you want to do that?
No.
Okay. And you also understand that if you wanted to exercise your right, your absolute right to have an attorney assist you, you could also hire an attorney of your choice. Do you understand that?
I do.
Okay, all right.
So I think what this video did a really good job of demonstrating are some of those principles of procedural justice that Judge Kuhlman just reviewed. This is not just kind of eye contact and speaking clearly. This is a judge who is speaking in a clear and concise way to a defendant, making sure that she's not only asking questions, but providing explanations. Judge Logan, I'll turn it over to you.
Thank you. As Judge Kuhlman has just aptly provided information about how amazing in a court the size of 200 that these powerful tools of procedural due process and individualized justice can be. Some systems can allow for that. Some municipal courts can allow for that, but there are some instances where this may be something that you as a judge in that position will have to take on by yourself. And there is room for that with the use of these tools. The concept here is that juxtaposition, sometimes that conflict between municipal courts and the politics in which the court sits and the pressures that may be placed upon the judge to make money for the entity in which they are sitting. And so it is important to always remember the neutrality in which we are supposed to operate. The courts of limited jurisdiction, municipal courts, are really known as courts of rehabilitation and not retribution. So it is leaning in on those principles and these principles of procedural due process and giving the voice neutrality, respect, and trust that may help in easing your way through this. I'm going to hit on some very specific topics where you can exercise that discretion that is yours and yours alone as the judge on the bench to sort out. I'll talk about public defender assignment, or at least making sure there's an attorney at all critical stages. Talking about bonds and alternatives, so least restrictive means that can be used, and then actually sentencing and alternatives that can apply there. So heading up to the public defender component of this, or just making sure that there is an attorney available from the very most critical first stages, like first appearance, for example. In some jurisdictions, the presumption is that if somebody is coming in as an in custody, that they would automatically be presumed to qualify to have counsel assigned to represent them. It may be that in your jurisdiction, there's a financial screening that has to be undertaken. But keeping in mind that these persons are in probably the most vulnerable position they've been. If they're incarcerated, if they're employed, they're away from that with the potential of losing jobs. If they have stable housing, that again, that can be placed in jeopardy depending on the length of time that they're incarcerated. And also keeping in mind that pre-trial, they are presumed innocent. So it is taking into the full picture the individual that is before the court, that will probably lead to the greatest amount of results and accountability, understanding that release is, for at least in the jurisdictions that I am operating in, is where you're supposed to lean to first, unless it's a capital case. So of course, in municipal court, we're not dealing with any capital cases, but there are cases that have a serious nature to them. So it's not taking that position lightly. And if there isn't in your particular jurisdiction a statute that provides for guidance in terms of assignment of counsel, some of the baselines that could help in assisting getting attorneys on board is the use of the federal poverty guidelines, which places, income levels of below 125%. The poverty guidelines qualify someone to have an attorney assigned to represent them. And again, the critical component of this, and I think it's a nice segue off of that last video that we saw where that individual was going to take on representation in a gross misdemeanor, thinking he had the legal acumen to do that. But having a trained attorney, as we know, makes a significant difference, not just in preserving the rights of the individual that's coming before the court, but the fact that you as a judge are making sure that that individual's rights are being protected is really enhances the trust component of what you can take on as your role as a judge. It provides some confidence that you really are there to preserve justice and not just rubber stamp decisions that are coming in, or that you are subject to special interests in any way, shape, or form. So there's a number of reasons to do it, besides the very most important constitutional right to be represented by an attorney. I believe in the materials that we're providing for you in a packet at the end, show some of the screening forms that we use here in the city of Spokane, and it's onerous. I'm not particularly proud of the screening tools that go on for that, because there are many instances where a great deal amount of money is assigned to a person who's supposed to have assigned counsel at no cost, but our statutes require that form of screening and then the application of a promissory note for them to pay on. Now, the amounts are low, but the whole concept of having assigned counsel for which you are paying, for me, rubs up against a little bit of the overall perception of having counsel assigned at no cost and not a no burden, a low barrier access to that attorney. So if there aren't those sorts of structures, those sorts of tools in place for your particular jurisdiction, I would encourage you to look out at other jurisdictions to see what they're doing. And I'd also encourage you to be participating in your local district or municipal court association, so that you might have some say in the legislature about making some changes about how that can take place. That is just even the assignment of counsel. But once you have an attorney on board and they are there to assist, then the next stage that I'm going to talk about here is as if in fact somebody is coming in before you and there is the request for bond, or you're determining release conditions for them. Here too, I would suggest that in our state, there is a statute, there is a structure that was created by our Supreme Court about the levels of bond that associate directly with charges. But with that can come also a barrier to access to bonding out. Certainly someone with means is going to be able to meet a nominal bond, but someone without means, you could set it at $10 and it's not something that's accessible to them. So while we do have that bail schedule, and schedules certainly help us keep on track, keep some neutrality when it comes to the charges that come before the court, there still needs to be that application of individualized justice to the person that comes before us. because of their varying circumstances. I mean, you can gain access to statistics about who's actually being held in jail. And as Judge Kuhlman has mentioned, 25% of the people that are incarcerated are on municipal cases, that is courts of lower jurisdiction type cases, and they are in pretrial status. So there comes a question of presumption of innocence in that, and pretrial sanction by being held on a bond that is not accessible. So it is also fine for you to vary from that bail schedule if the person before you, you gain the information about the person that is before you, that they are not of means. And the concept of a money bail is that that's going to be incentive for them to come back to court so that they don't face the penalties from the bail bond company if they don't appear, if they fail to appear, which would then result right in forfeiture of that bond and reincarceration. So when we were examining that, just as an anecdote, when we were examining that locally, you know, even the prosecutors got on board with that, and they were assessing $100 bond. Well, that was without discussion with bonding companies that said, we don't even, you know, we won't even post a bond at that's low. So thinking that we were doing the right thing with that, actually, we were sort of damning to a person to not be able to even access bond if they were able to obtain the means to do so. We found then that lower level, which was a $250 bond, and they pay a 10% charge to a bonding company if it's a surety. That was something that was more accessible even to those of moderate or low means, so that they would be able to gain access to freedom. Again, this is on a pretrial basis where they are presumed innocent. It is an unfortunate set of circumstances that someone is kept in jail pre-trial because they can't meet a bond. If it's for other reasons, for, you know, a history of failing to appear or violent crimes in their past, things of that nature, which are different considerations that certainly should be a part of the decision-making here. There should still be accessibility for them to be released. Handling failures to appear in court before I frankly ever get to a bond, there are many ways of approaching that would still preserve the rights of the city, in our instance, to proceed with cases where it could be considered that, okay, we're going to issue a failure to appear without issuing a warrant for arrest. Speedy trial would still be told, preserving jurisdiction, and there can be facts and circumstances that could be presented to the court that may make that compelling argument. Our sister court across the way in district court actually has a second chance docket, for example, where somebody may have failed to appear in one instance, and then they reappear on the next court hearing that they've given notice of, then the warrant is never issued, and that helps them in the future, so that if they are in a warrant status in the next instance, then this would not count against them. And that whole churning of in and out of jail, which is also likely to happen on a book and release on a warrant, is avoided. And again, all of this concept is about procedural due process, really attempting to get someone to trust the system and not just be penalized every time they walk into court for being late or having a misstep. It's another approach. Just sitting on your dockets is that instead of doing a roll call and instantly placing somebody who is failed to appear in a warrant status, is maybe waiting to the end. And not strictly going, you know, A to Z when you're calling that docket. It's just it's re-examining an approach that can fall into a very pedantic pattern that is very negative, has very negative, probably unforeseen consequences to the individuals that come before the court. In my last few minutes here, I would also like to then hit on sentencing and alternatives to sentencing. Certainly, you know, we have maximum penalties that are available to us, but for us, it's up to 364 days in jail and a $5,000 fine for gross misdemeanors. We have an in-between gross misdemeanor by virtue of some changes the legislation did regarding drug charges, which imposes a maximum penalty of 180 days and a $1,000 fine. But whatever the structure is in your particular jurisdiction, I would encourage you again to examine the person before you end the charge. Driving suspended in the 3rd degree has been a charge that has untold consequences for the individual that is indeed driving without the privilege to drive. But by having that privilege removed, the collateral consequences are not an inability to get, family members to school or get themselves to work or continue to be productive members of our society, which is really what we're all about. It isn't to churn them through the system in a punitive way. Our Supreme Court, just as a segue, our Supreme Court has absolutely defined courts of limited jurisdiction as courts of rehabilitation, not retribution. So in that rehabilitative model, it is an effort to determine what was really going to improve the circumstances for this person so they don't ever have to come back into the criminal legal system, which I think Judge Cooke is going to touch on is that just coming into the system can be punishment in and of itself. It's a very confusing thing to navigate. So when it comes to sentencing, it is really viewing it with the eye of what would indeed be an accountability piece for this individual, as well as a rehabilitative component of that. If you don't have a lot of resources, there are things that can be done just by the judge by virtue of bench probation, having them come sit for day reporting, for example, or I loved hearing about the diversion program for persistent offenders. In my community court, we have a version of that where somebody is misstepping, we'll set them down with an iPad, and they will have to commit to about a half an hour's worth of time, but it's an education piece designed to hopefully improve their behavior, give them some understanding as to what their behavior is in the world of the community in which they are living, in an effort to educate, to move forward in a positive way. Sometimes those violations that come before the court, jail is the answer. So, I mean, the only answer, but taking into account if they're employed, for example, is it possible for them to do weekends or some chunk of time that doesn't interfere with the fact that they have a job and a family that they're attempting to support, or even just themselves? It's taking those things into account. So there is an accountability piece. There is a community safety reflection in all of that, but there is also the individualized justice in an effort to support this person as they make their way through the system, again, with the hope that they're not going to come back and with the idea that they're not going to elevate up into a felony. All of those alternatives that I have provided here for you, including making sure that there's an attorney on board right to begin with, when the public sees that a judge is truly invested in that, that is where what Judge Kuhlman was talking about, where that procedural due process, where the individualized justice really comes into effect and gives trust and confidence that indeed they are not just there to punish them out of behavior. The researchers in this field who have no bone to pick other than just an evaluation have told us time and time again that continuous and constant jail is only going to result in continuance and constant jail for a person. That the terms and conditions that can be imposed that don't involve jail stand a much better chance of elevating someone out of the system and into a more healthy and healthful life, which is really what we're all about here. And it also allows you to have those kinds of conversations with your local political entities, because you'd certainly want to keep track of how your alternatives are having an effect on the population that you're serving. And if there's any criticism that comes from them, it's a demonstration by you of how effective it can be to choose these alternatives instead. With that, I want to make sure that Judge Cooke has plenty of time for her presentation. So I'm going to end there and hand it off.
Thank you, Judge Logan. Thank you for that. As Judge Logan said, we are going to be turning now to Judge Cooke, who is going to walk us through some additional best practice suggestions, as well as kind of a deeper dive into access to justice. You'll see there's going to be some slides here with Judge Cooke's presentation, just letting all of our participants know that we'll make this slide deck available to you following the webinar. Okay, Judge Cooke.
Good morning, good afternoon, wherever you are, and thank you. Lindsay, could we please back up the slideshow to the slide that's immediately after Judge Bachman's video? Next one. Perfect. Thank you so much. So I want to start out by talking very briefly about the fact that in webinar 3, we heard about municipal courts as potential sites of racial and socioeconomic disparities. And one of the overlays of best practices is that they should be aimed at eliminating those in whatever stage of the proceedings those are occurring. This is a great slide that kind of illustrates that concept. So judicial decisions may be influenced by systemic drivers that correlate with their race, ethnicity, or socioeconomic status. As an example, for instance, people of color may have unequal access to education and employment, which could then influence the factors that judges consider in deciding on a bond or sentencing. Let's go to the next slide. So using checklists or guidelines, if you prefer, are shown to be one of the best ways to help us as judges circumvent these systemic drivers. And we think that raising awareness about implicit bias for us judges will cause us to change our behavior. And actually, again, looking at the research, it's the use of checklists or guidelines that really is the most effective. A really good book on this topic is the Checklist Manifesto. It's written by Dr. Atul Gawande, a medical doctor. And I want to give a nod to Judge Kelly Easton in Lakewood, Colorado, for bringing this book and its concepts to my attention. Let's go to the next slide. Judge Logan has already discussed fines, but here's a sample guideline for traffic fines that you could use to keep yourself consistent and honest. Next slide. Judge Logan has also discussed bonds, and courts do have statutory factors to consider, but here's a factor of, or a sample checklist of factors that are not rooted in the systemic drivers of disparity that could also be considered. And very much to the point that Judge Logan made about the fact that pretrial detention is often very disproportionate to what the ultimate outcome of the case could be in terms of a consequence. Next slide. Judge Logan also talked about failures to appear, and she had some suggestions for what you might do in that context. This slide also presents some additional alternatives. One of the things I want to talk about briefly is warrant clustering. This was the concept of one of our prosecutors in Boulder, Colorado. And in our court, warrants are not issued until a person has failed to appear in at least 3 cases. Now, those are lower level cases. We're not talking about domestic violence cases, but camping, trespass, those types of offenses. And so this is really helpful from a resource standpoint in the sense that arresting officer, jail booking staff, they're not going through the process 3 times, but instead they're only going through it once. And there was actually a study of this practice by the University of Northern Colorado, which really validated the savings associated with that. And let's go to the next slide. All right, and then I'd like to talk a little bit now about the front end of a case where there's an opportunity for a diversion or dismissal. With diversion, cases are typically diverted from the criminal justice system entirely. So in Longmont, Colorado, for example, police divert juveniles to a restorative justice program in lieu of issuing them a criminal citation. So they never even enter the criminal justice system. There's no documentation of their shoplift, for instance. In Boulder, Colorado, the prosecutor dismisses low-level violations for the unhoused when they complete an alternative sanction. And that alternative sanction is beneficial to them, which means it's ultimately beneficial to the community. So examples are getting important documents such as IDs or social security cards. Those are needed for employment, for permanent supportive housing. So again, benefit to society. Other examples are working on housing, getting healthcare, or participating in mental health treatment. homelessness is a big problem in Boulder, Colorado, but that may not be a big problem in your community. So dismissals after completing alternative sanctions should be tailored to what's going on in your community. In an earlier webinar, Judge Skagit in Washington mentioned relicensing clinics for people who have lost their licenses. Judge Sparks from Birmingham talked about offering life skills training. And so his population is a lot of people who've not had sufficient access to education or life skills. And that's what is working to earn dismissals in his community. As you can imagine, there are endless opportunities to get creative and often to partner with community organizations. All right, next slide. All right, and we should also talk about best practices and how they should increase access to justice. We need to remember that there may be people who are hard of hearing, who are visual learners, or in some other way don't take in information in the way it is traditionally delivered in courtrooms. Most courtrooms today have a monitor. When I was the presiding judge in Boulder, I used a PowerPoint at arraignment. It accompanied my advisement of rights, my explanation of the process, and the guilty plea colloquy. So at every step throughout that process, there was me speaking, but there was also some text on the monitor that would help people who might be hard of hearing, for instance, follow along. I also had a PowerPoint that I used for jury selection. All right, next slide. Requiring people to come to the courthouse is another situation that can create barriers that denies access to justice. So virtual court, which is easy to set up with Zoom or another platform, in which probably all of us or most of us adopted during the pandemic, is a simple way to make court appearances easier, and it reduces failures to appear. Next slide. And then the final thing I want to talk about is that requiring people to come to the courthouse is particularly problematic for people who are unhoused. It means they have to abandon their few possessions and their pets, which they frequently have to come to court, so they often don't. So one of the things you could consider is creating an alternative location. So this picture is actually Boulder's community court. The person in the front in the blue shirt is one of the court navigators. The person in the front in the green shirt is one of the prosecutors, and across from her is one of the clients. And what you see going on in the background is the clothing closet, which is run by a local church, but is housed at the city's municipal building. And it's outside year-round, pretty much rain or shine. Only really cold weather is going to cause the event to be canceled because it's of danger if it's dangerously cold. But this is a place where people who are unhoused are gathering anyway. They're getting new clothes, they're getting usually a cup of coffee and a granola bar. So this was a logical place for us to choose to set up the community court. But as you can see from some of the other locations suggested on the slide, there are other places that you could consider as well. And if your target population is not the unhoused community, then think creatively about where you would find them. And if you can go to the next slide. The other thing to consider as you're setting up court at an alternative location is what other resources can you bring on site? Because you're probably already targeting one, and maybe it's a venue where they're already bringing in other people. So in the case of our Deacon's Closet, which is the name of the clothing closet, they were already having people from Clinica, our local medical provider for people who are on Medicaid, come. And so the slide that you see is not from our, with the doctor with the stethoscope, is not actually from our community court, but it is illustrative of street medicine, which is a thing, Google it. And this allows people to get medical attention while they're also at the clothing closet and at court. The slide on the upper left-hand corner is showing mental health treatment. And Boulder's community court actually does have mental health treatment on site at their community court. It's in partnership with Naropa University, which has a master's in counseling program. And any unhoused individual, whether they have a court case or not, can walk up and spend up to half an hour with a clinician. And many of them come just for that, not for court. And then, of course, on the right, that's another example of somebody attending court. And I guess I should have pointed out in the previous slide, the computers are the way that the judge participates. They participate by Zoom. So if they're looking at the computer, it's because they're looking at myself or one of the other judges and engaging with them about their case. And then finally, if you'll go to the next slide, I'm going to hand this back to Judge Logan. Because Spokane also has an amazing community court, and we took many of their concepts when we stood up ours in 2020.
Thank you, Judge Cooke. Yes, this is my heart, I have to admit. And we landed in the public library after a series of very deep dive conversations with a core group of people before ever standing this up. So while you're seeing this this is the after of those conversations. So I would provide for you my bad example. My bad example was I found this particular concept when I went to the very first convening of the International Community Court convention that was put on by the Center, what was then known as the Center for Court Innovation in South Dallas, Texas, where they had a very small courtroom that was nestled in, I'm envisioning this horseshoe-shaped building, which was the Martin Luther King Center, where they had resources from A to Z there. So federal work source, Social Security was there, there was community service that was available there, there was treatment that was available there. And I thought if in South Dallas, Texas, they could do that, we could do it in Spokane, but we didn't have any center like that. So we had to recreate something that would replicate what was so effective was not the court part of it. The part that was effective was having all of those resources without barriers to access. So we sat down and had these conversations. We had conversations with the police department about doing this because there was an unhoused population that was really being fairly disruptive downtown with the local businesses. And Spokane has no other revenue source than our tax base for the hospitality industry as well as retail. So we knew that it was important to support that as well as to support the individuals that were down there. And they were down there. We knew that they were not coming to court, even though they were being cited for trespass charges, for sit and lie on the sidewalk. Those are all charges that are available in Spokane, camping charges. They weren't showing up in our traditional court. So we spoke with the police department about doing some diversionary tactics and having that diversion be go to a location where you would be wrapped around with services. We had a conversation with the public library because we had actually had a life skills alternative class that they allowed the court to have there, much akin to Judge Sparks' concept of getting something available to someone to know how to, how do you sort out your monthly check if it's a limited amount? Don't spend it all on day one. So things of that concept. So we thought, they might be receptive to it. We came to learn later that the director told his assistant, I'm going to have this conversation with these court people, but I'm going to tell them no about holding court in the library. And then 45 minutes later, he came back to his assistants and said, we're having court in the library on Mondays, because it was in keeping with his concepts, which was that a library is not just books on the shelf. It's a resource. So while I'm telling you about all these rich details about it, what I would encourage you to do is have a conversation with your attorneys, with your police department. If you have a probation department, include them in this conversation about what is the population that we want to serve. It's a problem-solving court. What's the problem that we're trying to address? As Judge Cooke has already mentioned, if the unhoused is not your problem, is it a failure to appear issue? These concepts of alternative courts, the community court, are really to address those kinds of issues that you're sorting out in your jurisdiction in an effort to do something different. Because, right, the very definition of insanity is doing the same thing over and over again and expecting a different result. What we're doing here with these alternative courts and with this overall approach is saying, let's try to change the narrative about how we're trying to define our work. So we have this court in the public library, and we've had it, fortunately, since 2013. Thank you, Judge Cooke.
Thank you very much to all of our judges for sharing all of that information about the work that you've been doing for years in your particular jurisdictions. We have a few minutes left, so I wanted to chime in and ask a question. Hopefully we'll have some time for all of our judges to answer. But for jurisdictions who are kind of in the early phases of these types of changes, who are looking to build out some of these best practices that you've all described, I would love to get a little bit more insight into how you get buy-in from the communities that you're serving. And that can be, Judge Kuhlman talked about this very kind of comprehensive training that was done within his court space. Judge Logan had talked about getting this buy-in from the local library to create this partnership. But I'm curious if you can all kind of expand on that a little bit more. Who else should you be working with in terms of stakeholders? What are some of the champions you've had in your particular jurisdictions to help get change moving at a pace where it actually, you can see the progress, and then you can kind of report back to the communities. So Judge Kuhlman, we can start with you.
So I'm going to start by sharing a part of a prayer that I say every day. And what I say is, give me a heart for these suffering ones whom you yet love and hold dear in your own sacred heart. That is what we do in municipal court. We have hearts for the suffering ones. What are they suffering from in your community? Is it drug, alcohol, mental health? Is it housing? Is it recidivism? Figure out what your people are suffering from. The people who are the most frequent flyers, that's the group of people that you can make the most difference with. Then look around for the people who are already willing to help them. Somebody in the prosecutor's office wants to help those people. I don't care how tough your prosecutors want to be, they all want to help. Somebody in your faith-based community is there. Somebody in your reentry community is there. Somebody in the police community is there. Reach out with your ideas. Judge Logan said about the library, they said, we're not doing this at the library. Somebody presented the idea, bam, it's in the library. Talk to everybody. Police, prosecutors, community members, faith-based, talk to everybody, especially the ones that you think don't want to help.
Thank you, Judge Kuhlman. Judge Cooke or Judge Logan, please jump in.
Go ahead, Judge Cooke.
Well, what I was going to say is, you heard one of the other judges, I think, talk about how much time she spends talking with people in the different communities that she represents. And so I would say for us in Boulder, Colorado, it was really, really important to have pretty in-depth conversations with the city council, for whom the municipal judge works, about what you're trying to accomplish and what the specific program goals are, as well as sharing successes. Because you will, no matter how much outreach you do, there will be naysayers in your community. There will still be people who, the visible homeless, that they would rather not see at all, as an example. It could be a different problem in your community. So if your city council is behind you, then you're going to be okay. What's important, though, is to share with them the things that they really care about. So one of the biggest pieces of data that I shared was the number of incarcerations, days in custody, and the monetary equivalent of that before people were housed, and what it was after people were housed, or number of incidents and incarceration. And it was a fraction of 1% of people who reoffended once they were housed. And they were usually with very, very low level violations, maybe smoking in public because they'd gone back to hang out with their friends and they couldn't make the effort to walk to a legal place to smoke. So having that kind of data to show that, your end goal, in our goal, the end goal is housing, or in our court with the unhoused, this is what it accomplishes.
Thank you. Judge Logan?
The thing that I would add is it's really to start small first, as what has been mentioned. It is really talking to anybody they'll open the door, but you have to go in it with a core team. And so the mistake that I made in standing up community court, which is really the lesson I meant to impart, is I thought that my public defenders would just think this is the next best thing to sliced bread, but I didn't really include them in the conversation to begin with, making a very bad assumption that yes, it was, but they wanted a voice at the table as to how it was going to function. And, you know, was this going to be a baseball game, 3 strikes and you're out, which it is not. So it is vital to be very sensitive to your key players in it. And yes, there are, as Judge Kuhlman has mentioned, there are prosecutors that are leading these. Lead is a thing, law enforcement assisted diversion. And very often there are prosecutors that are involved in that because they don't want them to come back too. They too want a safer community, a healthier community. That was very eye-opening for me because I came from the public defender's office and I didn't have that much experience with prosecutors doing it. But when I came at it as a judge, I did have the prosecutor that was then ultimately one of the initiators, the core team. And with that team, we were then able to go out into the community and talk about what we were attempting to do. Collecting data is the very most important thing so that you can go, like Judge Cooke said, you can go to your city council or whatever your authoritative body is, understanding you're a separate branch of government, but you still want to make sure that they understand that what you're doing is better than what was in place before.
Thank you, Judge Logan. We are almost at time. Just wanted to see if there was any final thoughts from our judges before we do a little bit of final housekeeping.
I would just say, talk to everybody in your community. Keep open lines of communication, especially with the police and the prosecutors and the public defenders. Keep that open communication. See where there's common interests, where you can have common wins.
Wonderful. Okay. All right. Well, thank you again to all of our judges, Judge Timothy Kuhlman, Judge Mary Logan, and Judge Linda Cooke. We really appreciate your time. This was an amazing discussion. Thank you so much. And I want to thank all of our audience and our participants who joined us. Just as a reminder, this was number 4 in what will be a 5-part webinar series. You can expect the next one next month. There'll be some additional information coming out. Please continue to join us for the 5th in our series. And with that, thank you to everybody and enjoy the rest of your day wherever you are in the country. Thank you very much for coming.